and welcome to the LLG Grapevine podcast. You're listening to Deborah Evans, LLG CEO, and Dennis Hall, the LLG Bulletin Editor.
Hello, everyone.
Now, good morning to you all on about the 45th rainy day since the beginning of the new year. But hopefully the sun may be shining soon where you are. So let's see if we've got rain or sunshine in our articles today. So Dennis, what's first up today?
Well, yes, it's an article that appeared in the Law Society's Gazette concerning women leaving legal practice. An article in the Law Society Gazette has raised disturbing questions about the difficulties women face when pursuing careers in the law, especially to senior managerial positions. The headline of the article was, "Women go into and then leave practice in greater numbers than men." But why is this, and what can be done to stem this loss of talent? Women now vastly outnumber men at the point of entry into the profession. Almost two-thirds of solicitors admitted to the role are women, but women are much less likely than men to stay.
Now, under the age of 55, they leave at twice the rate of their male peers. Now, that's a significant loss of talent, knowledge, and experience. And the exodus is most marked in private practice. Perhaps too many law firms are still designed to favour people, disproportionately men, who fulfil fewer caring responsibilities. Now, greater flexibility would help, but sexism and sexual harassment also linger in many workplaces. And this is according to a report by journalist Maria Shahid in the Law Society Gazette.
Indeed, every year, some of the brightest women embark upon a job in the law full of drive and ambition, hopeful that a long and fruitful career awaits them in their chosen profession. But according to recent Law Society data, 53% of practicing certificate holders are women. However, the headline figure masks the fact that the profession is demonstrably bad at retaining its women solicitors, who make up almost two-thirds of newly qualified entrants.
Now, in private practice, somewhere between qualification and partnership, aspirations fade, and many women decide that the law is not for them. 6 in 10 female solicitors who leave the role are under 55, compared with just 3 in 10 male solicitors of the same age. For those who stay in the profession, there is a notable flight to in-house positions, in particular the public sector.
Now, Amandeep Khazria, chair of the Law Society's Women's Solicitors Network, explains the profession does not have a problem attracting talented women into law. She says the opportunity lies in retention, in redesigning career pathways so that more women stay, progress, and fully enjoy the rewards, recognition, and influence that leadership roles should bring. A study by the University of Birmingham Law School found that reasons for leaving ranged from supporting a partner or spouse's career to concerns about the hierarchy of law firms and worries about caring for children while fee earning.
Now, the Women in Law Pledge should be mentioned in this context. It was created in 2019 by the Law Society in partnership with the Bar Council and the Chartered Institute of Legal Executives to promote gender equality in the legal profession. Its object is to commit organisations to supporting the progression of women into senior roles, focusing on retention and promotion opportunities and setting clear targets on gender equality and diversity. The pledge has now been signed by over 200 law firms and organisations. However, at this distance from its launch, Khazria believes that the focus must now shift to ensuring those commitments translate into practical, non-performative change.
Deborah, I just wonder, is it time for local authorities to commit to a similar pledge to support talented women to proceed onto the most senior management positions in their organisations? And indeed, the broader question, what else can local authorities do on this? Comments, please, perhaps, to the LLG forum page.
Now, this is quite interesting, Dennis, because we had our EDI working group on Friday, and there were lots of thoughts there about practices in local authorities that can make life harder for women. And one of those is the tendency to have a lot of meetings in the evening, which obviously isn't easy if you've got caring responsibilities for children or the elderly, and also creates sometimes a feeling of unsafety at leaving the building late at night and needing to
Mm.
travel home on public transport. So one of the things that we'd like to do is a survey of our members just to find out what practices there are in local government that really are contributing to this. So more on that to follow.
Mm.
However, let's talk about something different. Now, ethics and integrity are rarely out of the news these days, and the Ethics and Integrity Commission is now setting out its plans for its future work. In a letter to the Prime Minister, the Independent Ethics and Integrity Commission has set out its progress since October and a programme of work for the year. Now, building on the Committee on Standards in Public Life's reputation for independent evidence-based work, the Commission has outlined the work now underway to deliver the EIC's new wider remit in the standards landscape.
The EIC's first review will examine the public sector ombudsman system. The terms of reference for this review and a call for evidence are expected to be published next month. The Commission will welcome contributions from anyone with an interest in how public sector ombudsman schemes can better identify systemic issues and bring about improvements to our public services.
And the Commission will also begin work to produce its first report on codes of conduct. This is in line with the planned forthcoming obligations of the Public Office Accountability Bill for public authorities. The bill will require all public bodies to establish a professional duty of candour for staff to be set out within a wider code of ethics, all based upon the principles of public life.
The EIC's work is intended to support public authorities to develop and embed codes of conduct into the culture and day-to-day work of their organisations. EIC Chair Doug Chalmers said, "We want to look at whether the powers the public sector ombudsmen have and the way they currently operate enables them to pick up upon themes and highlight developing problems in our institutions."
Now, going on, he said, this review, along with our work on codes of conduct and their oversight mechanisms within public authorities, is intended to raise standards to drive better outcomes for citizens.
Indeed, interesting. I'm sure there'll be more on that during the year. No podcast is complete these days without something on AI, Deborah. Satish Yaku, head of dispute resolution at RLK Solicitors, has drawn attention to the limitations of AI in delivering legal advice in an article in the Law Society Gazette. Now, this is a significant piece because it highlights the practical limitations of deploying AI in the process of giving legal advice and the consequences involved. And he says this: artificial intelligence is now firmly embedded in how businesses make decisions, and for many SMEs and company founders, AI-generated legal advice and DIY templates all feel like a sensible response to sustained pressure. He says tools that promise instant, low-cost legal answers feel practical, efficient, and commercially sensible.
But he emphasises, in reality, however, we are already seeing the consequences. Increasingly, disputes we handle can be traced back to businesses relying on AI-generated advice or running legal issues themselves without proper professional oversight. The problem, he says, is rarely that the advice is obviously wrong. More often, it is almost right. It looks polished, sounds confident, and appears to deal with the issues, but it is fundamentally misaligned with how the business operates, how disputes actually unfold, or where the risk truly sits. That false confidence is often more expensive than no advice at all.
And going on, Yaku says, as dispute lawyers, we do not see problems at the point advice is taken. We see them when positions have hardened, relationships have deteriorated, and outcomes are at stake. That is where the limitations of AI become stark. And he says this: legal issues do not exist in isolation. They sit within commercial relationships, governance structures, and human behaviour. AI is not built to understand bargaining power, internal dynamics, or how others are likely to react if something goes wrong.
In disputes, what matters is not whether an argument can be made, but whether it's the right argument to run, whether it sits correctly in the context in which you operate. And AI is particularly poor at that distinction. It can often throw out every conceivable point without differentiating between decisive action and mere noise. In live litigation, this can be dangerous, as poorly prioritised arguments can dilute credibility, distract from core issues, and actively weaken a case.
And Yaku is clear. One of the biggest risks of relying on AI advice is delay, and using AI without professional oversight creates a false sense of security. Businesses assume that the issue will blow over, they worry that legal input will inflame matters, or that they simply want to avoid cost. And the irony is that early advice usually reduces costs because it preserves options, evidence, and leverage. By the time lawyers are involved, the question is often no longer how to shape the outcome, but how much damage can still be contained.
He says it's important to emphasise that none of this is an argument against AI itself, and when used properly, it is a valuable tool that can assist with first drafts, issue spotting, summaries, and document organisation. Used in that way, it supports decision making. The key point is this: the risk arises when AI replaces legal judgment rather than supporting it. AI cannot assess risk appetite or develop negotiation strategy in itself. It cannot understand sector-specific realities or where leverage will sit if a deal starts to unravel. It can draft words, but it cannot judge how those words will perform in a live commercial dispute.
And Yaku concludes, legal judgment is not about legal theory, it's about outcomes. The stakes are not just the wording of a clause, but enforceability, evidence, leverage, reputation, and the knock-on effects across the business. Deborah, our coverage of the use of AI has a single consistent message, and it's borne out by this article. Don't rely on AI alone as a source of advice. At most, it can only ever be a component of good legal advice.
Well, thank you for that firm advice there, Dennis. Now, the Master of the Rolls, Sir Geoffrey Voss, has warned that generative AI will dramatically increase the number of civil, family, and tribunal claims, and that the justice system will need to embrace technology and AI if it is to cope. Speaking at the Justice for All event at the Old Bailey on the 4th of February, Sir Geoffrey noted that where litigants once relied on lawyers, the first port of call is now ChatGPT or Copilot, enabling individuals to turn personal grievances and large document sets into arguable claims at no cost. Courts must prepare for this AI revolution, he said.
Well, indeed. And the justice system will need to embrace and utilise AI if it is to cope with a sharp increase in the number and complexity of claims. So Geoffrey said the legal community has been short-sighted in its approach to technology and must now confront the implications of a rapidly approaching machine age in which AI, quantum computing and digital evidence systems will reshape the fundamentals of justice.
Artificial intelligence, he says, will soon be capable of delivering civil and criminal justice outcomes in a tiny fraction of the time taken by human judges and lawyers. He added that society must most urgently decide what role humans should retain in the justice system.
And Sir Geoffrey argued that the justice system cannot continue to rely on 19th century processes in a 21st century environment where disputes generate vast data sets, litigants increasingly use AI tools as their first source of legal advice, as we've just seen. Minor disputes can be resolved online in hours. And finally, society does expect justice to be accessible, fast, and affordable for all.
AI, he said, will inevitably be used to deliver many justice outcomes because it will be far more capable than many can now imagine and far cheaper than human-driven processes. Despite predicting widespread machine-assisted or machine-made decisions, Sir Geoffrey stressed that human judges must remain front and centre of final determinations affecting people's lives.
But interestingly, he did question whether a machine could ever constitute an independent and impartial tribunal under Article 6 of the ECHR, and warned that a fully automated justice system would not be acceptable to the public. The Master of the Rolls concluded that justice expectations have fundamentally changed. Society now demands equal access to justice for all, delivered quickly and efficiently.
Meeting that expectation, he said, is impossible without embracing AI, but doing so requires a principled, urgent debate about the boundaries of machine involvement in judicial decision-making. There is not a minute to lose, he warned.
Indeed, we'd agree with that. Now, turning to something else, driverless taxi services. Reported by the BBC, driverless taxi services could begin operating in the UK as early as this September, according to American company Waymo, which says it hopes to roll out a robotaxi service in London later this year. The UK government has said it plans to update regulations in the second half of 2026 to allow driverless taxis to operate commercially, although no exact date has yet been confirmed. And ahead of those changes, Waymo intends to launch a pilot service in April under existing trial arrangements.
Local Transport Minister Lillian Greenwood said the government is supporting Waymo and other companies through passenger pilots and pro-innovation regulations designed to bring self-driving vehicles onto British roads. Waymo displayed a fleet of its vehicles at the London Transport Museum earlier this month. The cars are already operating on London streets with safety drivers behind the wheel while they map the city. When the service opens to paying passengers, however, there will be no human driver.
Greenwood said that she expected autonomous vehicles to make roads safer by reducing human error. She said automated vehicles don't get tired, don't get distracted, and don't drive under the influence. She added that strict safety standards would still apply, including protections against hacking and other cyber threats. The government estimates the autonomous vehicle industry could add £42 billion to the UK economy by 2035 and create nearly 40,000 jobs.
Now, passengers will be able to hail Waymo robotaxis via a smartphone app once regulations permit. Airport drop-offs will not be available initially, however. A Waymo spokesperson said fares would be competitive but premium, rising during periods of high demand. Waymo says its vehicles have driven more than 173 million miles fully autonomously, mainly in the United States, where it operates around 1,000 robotaxis in San Francisco and 700 in Los Angeles.
However, there have been isolated reports of vehicles malfunctioning, with some passengers temporarily unable to exit the cars. But the key questions for licensing practitioners do exist, don't they? What legislative changes are needed? And how will the role of local authority licensing authorities change? Once again, answers please to the LLG forum page.
Now, Dennis, we can't end a podcast without a Missouri story, and this story provides some good news for CILEX applicants for litigation rights. CILEX regulation has made a number of time-limited amendments to the practice rights application process after representations were made that portfolio applicants affected by the Missouri judgment now face challenges when completing applications.
Indeed. Following feedback from the CILEX support group, the regulator said that the amendments will be as follows. First, I'll go through the various headings with you, Deborah. The first one is age of evidence. They say, recognising the exceptional circumstances arising post-Missouri, the regulator will now accept relevant litigation advice gained in the preceding 5 years, and this is an extension on the current 2 years. Next, work-based learning, known as WBL, and professional accreditations. WBL assessments and relevant professional accreditations obtained within the 10 years preceding an application can now be used to support an application, but they emphasise that this cannot be considered as an exemption.
And then there's the reuse of accreditation evidence. Where relevant, evidence used in a work-based application or third-party accreditation scheme can be reused in a portfolio application, provided it maps to the relevant requirement. And this will be given the same weight as more contemporary evidence that may be submitted. Evidence previously submitted can be up to 10 years old.
And finally, on the topic of expedition through the assessment process, the regulator will consider whether evidence of current accreditations and previous experience can enable applications to be expedited through the assessment process, and this will be considered on a case-by-case basis.
Now, CILEX regulations said that these amendments will operate until the 30th of June 2026. The regulator says to benefit from these relaxations, applicants need to submit completed applications by that date. They will keep this date under review and will consider an extension if necessary, because the 30th of June is going to come round quite quickly. Now, David Thomas, core member of the CILEX support group, said, "We welcome the adjustments CILEX regulation have made to the evidential requirements placed on applicants. This reflects feedback that the CILEX support group presented to the CILEX regulation from chartered legal executives affected by the Mazur judgment."
And just as a reminder, on the 24th of February, the Court of Appeal will hear an appeal over the High Court ruling in Mazur against Charles Russell Speechlys, in which Mr. Justice Sheldon famously concluded that an employee of an authorised firm cannot conduct litigation simply by virtue of their employment, even if supervised by an authorised person.
And on that bombshell, that's it for another edition of the podcast. You can read more on that, the items discussed today, and many, many more besides by going to bulletin number 6, available on the LLG website now. So it's goodbye from me.
And from me too. Bye-bye now.
Thank you for listening and have a good week.